My name is Lubomba Halwampa. I'm a law student at Taylor's University. In this video, I will critically analyze the factors considered by the courts in deciding the application for a delay of possession order, which arose from the case of Cheltenham and Gloucester Building Society versus Grant, where North LJ stated that it is not the court's role to put down precise standards for judges to deal with proof on the power to suspend an order for possession of a dwelling house. To begin with, I will start by defining what a mortgager, and mortgagee is. A mortgage is a contract between a person and a lender that provides the lender the right to repossess your property if you are unable to repay the loan plus interest. A mortgager is someone who borrows money to pay for their home. The mortgager is often referred to as the borrower, and the mortgagee is an entity that lends the mortgager money. This entity is typically referred to as the lender. As per the case mentioned earlier, a mortgager fell into arrears on mortgage payments, and the issue was whether the mortgagee could take possession and whether the possession could be postponed under Section 36 of the Administration of Justice Act 1970. The courts determined that the starting point for a reasonable period of postponement under Section 36 is the remaining mortgage term, but there must be consideration given to 1. A mortgagee's budget, 2. How much the mortgager could pay, 3. Both now and in the future, how temporary the mortgager's difficulties in paying will last, how much of the original mortgage term is left, why have arrears accumulated, when is repayment due, is it responsible to deny recouping of interest by a mortgagee as originally planned. Moreover, the possession was allowed but postponed until the end of the mortgage term. When the mortgage is first taken out, the mortgagee has an unqualified right to possession under English law. The right has been limited by case law and statutes. However, the notion that a mortgagee can achieve de facto vacant possession of a property by using contractual and/or statutory rights of sale or self-help that are not subject to comparable constraints appears to have escaped English law. When such powers are legitimately utilized, a mortgager's rights are released to the following purchaser. The mortgagee receives his money, the second purchaser receives a new property, and the mortgager loses their house without having to go to court because these powers do not require a court order to be used. The stance has been reaffirmed by case law in the 21st century, and the passage of the Human Rights Act of 1998 has made no difference. This apparent weakening of the constraints on the mortgagee's right to possession sparked a slew of changes and recommendations in response to public concern over the risk posed to mortgagors who may lose their homes in the event of a modest default with no chance to defend themselves in court. Some measures have improved the protection of mortgagors in practice, while others have not. A radical legal adjustment aimed at correcting this anomaly is likely to have negative economic consequences that outweigh the benefits of additional protection provided to borrowers or mortgagors. A mortgagee has an unqualified right to possession of a mortgaged property subject to any express or implied contractual limitations before the ink is dry on the mortgage. In the case of Four Maids Limited versus Dudley Marshall, on the case facts, a possession order was granted but postponed for 2 months given interest arrears. This case was found that a mortgagee could go into possession of mortgaged land at any time after the mortgage was granted unless prohibited by the mortgage agreement. Moreover, as per the case of White versus City of London Brewery Company, it was established that the brewery company must account not only for the rent which they received, but also for the increased rent which they might have received if they had let the public house as a free house. Also, in the case of Birmingham Citizens Permanent Building Society versus Count, the courts placed modest limits on this right, stating mortgagees must have mortgagors 28 days to discharge the entire debt as long as there was a reasonable prospect such payments could be made. Also, in the case of Carnell versus Maltby, the Court of Appeal established that actions was not to shield her security but at the ulterior motive of assisting her husband to obtain vacant possession by ending a lease that he had granted. Additionally, the court could not assist the party to undo the consequences of his own authorized act. Statute then placed greater limits on this right through Section 36, subsection 1 and 2 of the Administration of Justice Act 1970. As amended by Section 8 of the Administration of Justice Act 1973, these sections empower the court to suspend, postpone, or dismiss the execution of a possession order for such period as the court thinks reasonable, if it is likely the mortgagor can repay within a reasonable period, thereby giving mortgagors a certain degree of protection. However, English law contains a curious anomaly that mortgagors are given more protection when mortgagees bring court proceedings to realize their security than where mortgagees bypass the system completely. When a mortgagee exercises a contractual and implied statutory right to sell under Section 101, subsection 1 of the Law of Property Act 1925, the mortgagee is under no obligation to obtain a court order when exercising that right, according to the case of Ropeglich versus Barclays. The court held that Section 36 of the Administration of Justice Act did not require the defendant to obtain such an order for possession. Moreover, a mortgagee is entitled possession at any time he chooses, and according to Section 2, subsection 1, part 3 of the Law of Property Act, the subsequent purchaser will overreach the interests of the mortgagor. In strict legal terms, the statutory intervention under Section 36 of the Administration of Justice Act aimed at protecting mortgagors is thus rendered impotent. There was some optimism that the Human Rights Act would fix this problem. However, the case of Horsham Properties versus Clark shattered those dreams. In addition, the mortgagee's implied statutory power of sale under Section 101, subsection 1 of the Law of Property Act. The defendants had failed on their mortgage repayments, and the mortgagee had a contractual right to sell the mortgagor's property to recover their security under the terms of the mortgage. The mortgagors argued that the mortgagee's sale of their property to a third party and subsequent claim for possession violated a number of Human Rights Act convention rights. Their fundamental contention was that it was their right to peaceful use of the land. Their major claim was that their Article 1, First Protocol of the ECHR, right to peaceful enjoyment of their goods, had been violated. This would need them to demonstrate that their equity of redemption was a possession under Article 1, Protocol 1, but government involvement had taken away their right, and that deprivation was not in the public interest. The court, on the other hand, dismissed the argument on all accounts. While the court agreed that the mortgagor's equity of redemption was a possession under Article 1, Protocol 1, it dismissed the notion that this article had been applied in the case since the mortgagor's equity of redemption had been forfeited by the contract rather than legislation. Briggs J. then addressed the wider issue of whether Section 101 engaged Article 1, Protocol 1. Legislation can constitute the requisite state intervention, but only if it represents a deprivation of an applicant's convention rights rather than a mere delimitation of them. In the case of Wilson versus First County Trust and Penny versus Cook shows are evident cases for this scenario. It was concluded that Section 101 did not deprive an applicant of their rights under Article 1, Protocol 1, as it had the effect of helping to implement the private bargain of the parties rather than overriding the bargain entirely, and consequently the bar to the claimed right was neither rigid, arbitrary, or discriminatory. Briggs J. went on to state that even if the mortgagee's sale out of court was construed as a deprivation of possession, it would not amount to breach of Article 1, Protocol 1. It could be justified in the public interest as it reflected the previous 200 years of mortgage dealings, and that any adjustment to the balance of power may result in a restriction of of the availability of mortgages to the wider public at affordable rates of interest. Also, the convention was intended to deal with arbitrary intrusion by the state into citizens' lives. In the case of Harrow London Borough Council versus Kwasi, the courts determined that Article 8 does not, in terms, give a right to be provided with a home and does not guarantee the right to have one's housing problems solved by the authorities. The expiry of his wife's notice to quit brought his right to occupy the house as a tenant an end, but it did not bring his occupation to an end. The house continued to be the place where he lived, and so was his home. It was certainly not intended to tilt the balance of power struck by law in states between lenders and borrowers in favor of borrowers. However, as a result, several ideas and improvements have surfaced. Some strengthened the protection of mortgages, while others did not. The pre-action mortgage protocol and the House Possession Court Duty Scheme are seen to have enhanced the protection of mortgagees. The protocol, which went into effect in November 2008, which encourages lenders and borrowers to talk about the borrower's financial status and requires them to look into measures to help the borrower before seeking possession. The protocol appears worthless at first inspection, reinforcing the claim that it is a total waste of time and paper. However, there is evidence that it is having a favorable effect. All parties engaged in domestic mortgage repossessions have mostly accepted the protocol. According to the Ministry of Justice, the protocol is very likely to have resulted in a significant decrease in possession claims. The number of claims was stable at roughly 38,500 in the first 3 quarters of 2008. But once the protocol was implemented in the fourth quarter, the number plummeted to 26,008. In February 2009, the Council of Mortgage Lenders predicted that 75,000 repossessions would occur that year. However, this figure was reduced in June 2009 and again in November 2009 to an expected 48,000. Wood also considers the court scheme, which gives free legal counsel to mortgagees, to be a major step forward in providing protection. The government launched 2 measures that promised a lot but didn't deliver. First, in January 2009, the Mortgage Rescue Scheme was created, allowing mortgagees in arrears to stay in their homes by allowing a social landlord to purchase a whole or partial equity ownership in their house. Second, in April 2009, the Homeowners Mortgage Support Scheme was launched, allowing borrowers in financial distress to defer interest payments for up to 2 years. These amendments appear to strengthen mortgagor protection on paper, but their protocol uptake suggests they are having little impact. Only 16 borrowers were assisted under the Homeowners Support Scheme in July 2009, and only 92 borrowers were assisted under the Mortgage Rescue Scheme in 3 months leading up to November 2009. Given that yearly repossessions number in the tens of thousands, these results support the claim that too strict qualified standards prohibit enough lenders from receiving assistance to make substantial difference in strengthening mortgagor protection. Changes in the law have also been sought. The Citizens Advice Bureau contended that first charge mortgage lenders should not be able to exercise the power of sale or self-help over a residential residence without a court order. And Andrew Dismo, MP, sought to propose a private member's bill to do so. The Council of Mortgage Lenders, on the other hand, has warned against substantial changes to the legislation, claiming that they might have far-reaching consequences for lenders, customers, and the economy. While these suggestions would provide additional safety for mortgage borrowers, they may force lenders to be more cautious when extending credit, and a depressed lending market would do nothing to assist the economy recover. The cost of lending would rise, limiting access to credit for a larger proportion of the population. Finally, there is little indication that mortgagees are adopting the Horsham possession method on a large scale, and it is actually in the lender's financial interests not to do so in a depressed home market. In conclusion, a mortgagee now has the legal power to evict a mortgagor from his house without obtaining a court in order in the case of default. This might be accomplished by utilizing contractual clauses in the mortgage deed or by utilizing legislative authority. The fact that this was confirmed in Horsham triggered many of the revisions and recommendations. Some amendments have been commended with providing better protection to the mortgagors than previously existed, while others have been criticized for having extremely qualifying conditions that preclude them from having any impact. There has been some request for legislation to be changed in this area to provide existing mortgagors more protection. However, this would come at the cost of higher borrowing prices, excluding more people from house ownership and jeopardizing the UK's economic recovery chances. In the absence of proof that mortgagees are using the Horsham possession method on a large scale, any legal reform should be avoided.